Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hochman, LLP, a premier litigation and art law boutique in New York City. All right. Hi, Steve.
Hi, Katie. How are you?
I'm good. We are back to talk about NFTs again.
Our favorite topic.
Our love-hate topic.
Well, after we talked with Amy Whitaker last time about some very broad potential economic and structural and societal issues presented by NFTs, but today we're going to be discussing some important intellectual property issues surrounding NFTs that were underscored by the decision and jury verdict reached on February 8th in a case brought by the fashion house Hermès against a person who goes by the name of Maison Rothschild.
That's a very fancy-sounding name, too.
Yeah, well, of course, it's not his real name, but we'll get into that. And this is, of course, the case about Meta Birkins. And to help us unravel this case, we are joined today by Emily Poehler. Emily is the founding partner of Poehler Legal. After graduating from NYU Law School, Emily began her career at the preeminent Manhattan law firm of Cahill, Gordon, and Rundell. She then made a brilliant career move and joined the then ascending litigation and art law boutique of Schindler, Cohen & Hochman, where I was privileged to practice with her for almost 12 years. At Poehler Legal, Emily represents a broad range of clients, including software as a service providers, direct-to-consumer brands, trademark licensors, art collectors, galleries, and more. Emily has been closely following and writing about the Meta Birkin case, so we are thrilled to have her in the studio to talk about it. Welcome to the podcast, Emily.
Thanks, Steve. Thanks, Katie.
Yeah, it's so nice to see you. And even when we work together here, you are our resident trademark expert, so it makes total sense you're here to guide us through this. All right, let's start, Emily. What is a Meta Birkin?
So in about November of 2021, Maison Rothschild, the gentleman who goes by that name, released a collection of about 100 NFTs, and each NFT was accompanied by an image of a faux fur-covered bag that resembled a Birkin bag. And for those not in the know, a Birkin bag is an extremely expensive, very rare bag that is hand-produced by Hermès and has been, I think, since maybe the early 80s, and it's named after the French actress Jane Birkin, who, I guess lore has it, wanted an Hermès bag that was big enough to carry her kids' diapers and milk bottles.
It's the least child-friendly seeming handbag you could imagine.
Yeah, I personally,
Family
after
friendly.
spending 5 figures on a bag, would not be sticking diapers in it, personally, but that's just me.
And who is Maison Rothschild?
He is a quote-unquote marketer, and he's designed some clothing, and he's sort of a multifaceted artist, marketer. It's sort of hard to pin down exactly what the right word for
Content producer, maybe?
Content, that would do. Yeah, that would work.
So he content produces these Meta Birkins, you said are sort of NFTs linked to images of objects that resemble the Hermès Birkin bag?
Correct. I do want to note that the actual Birkin bags are, one, they're physical handbags that you can, carry around. And two, they tend to be made out of anything from leather to very luxurious, like ostrich skins, whereas the Meta Birkins are covered in sort of almost garish fake fur. They look sort of almost like a Muppet was put on a handbag.
Yeah, and of course we'll link to some of these images in the show notes so people can see, but it's basically a bag in a white frame covered in fur.
Correct. And one of the things that did come up, and maybe this is just foreshadowing because maybe we'll come to talk about this later, one of the things that was raised by Hermès was the fact that, at least initially, there was sort of this an image that was draped with like a white cloth, and that was pre the minting of the Meta Birkins, and then when they were minted, that preview image was replaced with the actual Meta Birkin.
So if I were interested, if I had been interested in purchasing a Meta Birkin, would I not know what it would look like until I actually purchased the NFT? Like, and the cloth was sort of figuratively removed?
Correct.
Okay.
Yeah,
That's
so
my understanding.
what brilliant marketing. So he made people kind of buy in, get on a wait list basically until the NFTs were actually
Correct.
minted.
And this was all, and these were, now sitting here in early 2023, I mean, to sort of think back to where we were in late 2021, the hype around NFTs and people sort of wanting to get in on things ahead and sort of catch the next wave. I think, you sort of have to think back to that moment.
I didn't understand it then, and I still don't, so that's helpful for me. But for other people, it may be. Okay, so give us a sense of the value of these NFTs. What are we talking about here?
Oh gosh, I'm blanking, but I think they were in the range of about $1,000.
And then they traded up, right?
Yeah,
I
they did.
remember
They did
reading-
trade up, and then Hermes sued, and then maybe I'm getting ahead of myself, but then the value decreased.
Yeah.
And I believe that OpenSea pulled them off of the market. OpenSea is a market for NFTs, and I think just prior to the lawsuit being filed, OpenSea pulled the Meta Birkins.
Yeah. I think I read somewhere, but no one get angry at me if I'm getting this wrong. We will check and link to some resources. But I think I read that they were retrading into the tens of thousands of dollars at some point. So it's not nothing.
Yeah, I think about 10. I think in the low five figures range.
So Mason, as we'll call him, or Mason, he.
I think he probably prefers Maison.
It's missing, but it's missing the I.
It is.
With Maison.
All right,
in
Mr.
French.
Okay.
Mr. Rothschild has this idea for these NFTs. He mints them, but he can't do that on his own, right? He has to use partners to do that and to sell them. So who are the different players who are getting these to the market?
Correct. So as I understand it, there's a person who helped him, who's sort of a tech person.
Yeah.
Let's see.
I think it was interesting.
Burden is his name.
He was characterized differently by the two different parties. I mean,
Yeah.
it has some legal relevance that he was basically, from Mr. Rothschild's point of view, he was an assistant.
Right.
Right. And from Hermes's point of view, he was the artist.
Yeah.
Right.
Yeah.
Right. So he was the person who, provided technical support, and from, as Steve just said, from Hermes's view,
Did all the design.
He did all of the design and sort of input whatever needed to be input into the computer to make these images happen.
So they make these images and then but they don't mint them themselves. They use a provider to actually mint them. And then how do they sell them? That's where OpenSea is.
That's where OpenSea comes in, and OpenSea is a marketplace for the sale of NFTs, for reselling as well as initially minted.
And just as a technical matter, if OpenSea then pulls the Meta Birkin, so to speak, can they still be sold?
They can still be sold, just not on OpenSea. You can sell them somewhere else. It's like, to sort of bring this back to art, it's, if Gallery A has works by a particular photographer up, and that gallery decides they no longer want to deal with the artist because of Me Too or whatever, then that artist could go to another gallery.
Right. But assuming that another gallery is willing to represent.
Assuming, again, I mean, sort of continuing this idea, like assuming that second or third or fourth gallery isn't like, oh, dude, you're toxic, I don't want to work with you.
Right. I think in the world of these NFT marketplaces, everyone is eager to make money, and I'm not sure there's a ton of discernment.
And I'm not sure that you're dealing with a world of people who are sort of super concerned about, following the rules.
Right. Or aware, even.
Or aware. Or, interested in checking them. I mean, I'm not seeing, this is not necessarily an industry at this point that has, a council on staff where people are going and saying, hey, can I do this?
Yeah.
Or what do you think of this before they're putting it out
Yeah, and
there.
to add complication to that, totally true, this area of law, art meets trademark, meets the First Amendment, is not crystal clear. So it's not like there's a rule that everyone understands, that there's a black and white line, which we'll
Clearly.
talk about.
Correct. I mean, I think, Steve, who was the judge who said, I know it when I see it, talking about pornography?
Judge Potter Stewart.
Yeah, I think we're a little bit in that realm here.
Yeah, and not everyone sees it. All right, so Hermes doesn't like this project, and that's why we're here talking about this.
Correct.
And so what happens? Hermes obviously finds out this is going on.
Hermes finds out this is going on. It sends a cease and desist letter to Rothschild and says, knock it off, stop selling these. And Rothschild says no, and Hermes sues
In pretty
Rothschild.
quick succession, actually.
Pretty quick succession. I want to say that the NFTs were minted maybe in mid to late November of 2021, and the suit was probably filed in either very late 2021 or very early 2022.
Yeah, it was like a month or two.
I mean, the suit was filed in early 2022, and this is, sort of a tribute to the federal courts that this has gone as quickly as it has.
Shocking,
Well, I think
actually.
it's a tribute to Judge
Yeah, you're right.
Rakoff to some extent, who is known for proceeding efficiently, and it really is amazing that you have a jury trial and 2 dispositive motions within a year, practically, a little more than a year.
14 months.
Yeah.
I guess before we dive into the specific claims, which we want to spend some time on, it's worth talking a little more about what Hermes said they were concerned about, and how that looked to an average person. So first of all, they send a cease and desist. Rothschild does not cease and desist, but a few things happen. He puts up a disclaimer, right?
Correct.
Says immediately, I have nothing to do with Hermes. They haven't blessed this. You shouldn't think that. And OpenSeas stops carrying or selling those NFTs, right?
That's right.
And he continues to sell on a couple of other platforms.
I don't remember the names of those platforms, but yeah.
But platforms nonetheless, and they keep trading these NFTs. But Hermes that's not enough. They feel like there's some infringement on their ability to market this brand, to make money off this brand, to control this brand. And it's sort of interesting that a powerhouse, an old, French, very fancy company like Hermes is threatened by this NFT marketer, who just throws up some pictures of fuzzy handbags.
Yeah. I mean, I do sort of wonder whether Hermes gave this fire a lot more oxygen than it could have.
Right. Then really threatened it.
Yeah. I mean, I think somewhere when this case first started, I was reading something about the history of Warhol and Campbell's Soup, and I guess at some point, I don't know whether it's true or not, but Campbell's made the decision not to sue.
Right.
And there was internal discussion at Campbell's about whether to sue Andy Warhol, and they decided not to.
Yeah.
And
It was a brilliant decision on
Yeah,
their
and it was
part.
and
Actually
I think
very good for Campbell's.
Yeah, I mean, I think it sort of brought a somewhat stodgy brand and gave it a little bit of hipness that didn't hurt the brand. And on the flip side, as a trademark owner, and we can get into this more, Hermes does have to police the use of its brand, and if it doesn't, it faces the possibility of losing control of the trademark, which no trademark owner wants.
Yeah, and it is critical to Hermes's business, certainly, even if this particular NFT, we might not think it was so confusing. All right, so what's the dispute about?
So there's a couple of different claims, but really the biggest one, and I think the one that most people have focused on, is Hermes claims that by using the term quote-unquote meta Birkin, Mason Rothschild has infringed on Hermes's trademark in the word Birkin.
And why? I did read this in some of the papers. I mean, I guess the claims technically are about the mark of the name, but also the mark of the design and the trade dress, but they do seem to focus more on the name.
Correct. And my understanding is that Hermes did not sue on the trade dress. They sued on the mark, on the name Birkin, rather than the
design.
And I suspect, I don't entirely remember the reason for that, but there's sort of 2 things that come to mind. One is that these bags are fur, and I mean, yes, they have the same shape, but physically they appear differently than the physical Birkins. 1, and 2, they're digital images and not physical bags, and I believe that Hermes's trademark, their design mark, was for the physical item and not for the NFT, and that in fact they hadn't gotten round to filing a new application to cover Birkins in the metaverse.
Yeah, although I guess they still could have brought a trademark claim based on
Common law.
on the image. And I thought they originally did do that, and it just sort of got lost by the wayside. No.
There was some discussion of that in the initial pleadings, and then sort of as time went on, Hermes focused
On the name.
Right. And they also brought something called a cyber squatting claim.
Correct.
And just could you explain
Sure.
what that is?
I mean, like I said, there's a couple different threads. Most of the attention has been focused on the trademark infringement. One of the other claims that Hermes brought is a claim for cyber squatting. There's a federal law that says you can't take somebody else's URL and use it in bad faith. So if Schindler, Cohen, and Hockman, for example, has a website, which they do, I can't go out and take that and sort of sell my own stuff using that URL is the essence of that claim.
So the trademark, maybe let's take a step back. We've talked a lot about copyright on this podcast because we talk about fine art. We've talked less about trademark. Can you just give us a very easy to understand explanation of what trademarks are, how they're different than copyright? And if you want, I mean, one thing I'm curious about is why there were no copyright issues in this case. You know, why this is really about trademark, even though it's intersecting with so-called art.
It's a good question because I think that's gotten lost in the sauce in a lot of the discussion about this case. So trademarks at a really basic level tell consumers where a product comes from. So if you see, just to use a super famous example that I think everybody, even though we're doing this as a podcast, everybody can see in their head, a box from Tiffany. Everybody can picture that color, and when you see something a box in that color with a little white ribbon on it, in that robin's egg blue, that box came from Tiffany.
Right.
That is the epitome of a trademark. The Nike swoosh is another super example. You see that swoosh and that product was made by Nike. And so copyright protects a creator's investment of time and energy in making something, whereas a trademark has sort of two functions. One, it protects the trademark owner's interest in the brand and sort of ability to market its products. It also protects consumers' abilities to know where a product comes from and the source of that particular product.
Right. The heart, I think of it as like the heart of copyright is in protecting creators and incentivizing them to create. Trademark's not really concerned with creators. It's concerned about protecting the public against confusion.
Correct.
For the most part.
And it's I mean, that is the purpose. It's also, I think, come to be increasingly over time concerned with protecting brands and their investments in making sure their trademarks are known or the extent to which their trademarks are known by the public.
Right, and that also, accounts for the fact that to some extent why a trademark owner brings a lawsuit like this. Obviously, you can say that they're concerned with protecting consumers, et cetera, but they are clearly protecting an economic interest in their own brand. Right?
Yeah, and they could get damages that represent the economic loss. So it's absolutely true. Although when you look at the analysis, what Hermes, unlike if they'd brought a copyright case, what they had to prove here essentially was that this was confusing to the public. So that was where the evidence sort of developed.
Yeah. And two other differences between trademark and copyright law that I think might be worth noting. Unlike patents and copyright, trademarks are not mentioned in the U.S. Constitution. And two, trademarks are generally speaking for an unlimited period of time. They don't sort of sunset as long as the trademark owner is vigilant in protecting their rights and enforcing the trademarks through things like cease and desist letters and filing.
And using the trademark.
And using the trademark. So use of the trademark, you will lose a trademark in a couple of different ways, but one is if you cease using it.
Right. And I think we'll talk about this in the First Amendment context too, whereas obviously there are First Amendment concerns and sort of protections in the copyright regime. We talk about fair use, there are terms, there are things built into copyright, but it's much less concerning because of the constitutional mandate of copyright. And when we have trademark, a creation of Congress, we think about the First Amendment concerns in a much different way, which this will come out in this case and why art is different. All right, so
So we know that a jury heard this case in late January, early February, and rendered a decision on February 8th. But before that, the judge had to do some consideration of some of the legal issues in the case. And actually, right before, I guess, the trial, or at the time that the trial was beginning, Judge Rakoff handed down his summary judgment decision. And maybe we should start there and talk about what the judge did, and then we can go and talk about the trial.
what he did during the trial.
That was kind of interesting. I presume that he
He issued his decision way ahead of time, but not the reasoning for the decision.
right, and I presume. I wasn't in court that day. I presume that he indicated in some shape, manner, or form to the parties prior to actually issuing his written ruling, which came down while the trial was going on.
What the reasoning was.
Right.
Yeah.
So both parties, and we can say this for the non-lawyers in the audience a little bit, before a case gets to trial, the parties have a chance to ask the court to render a decision making the trial unnecessary. And the basis of that decision, called summary judgment.
Actually, at two junctures, right?
I think that's
Yes.
And that happened, they both happened in this case.
Right. There's a motion to dismiss at the outset of the case, which Mr. Rothschild made and lost. And then there was summary judgment, which was decided right before the case went to trial, where both parties basically said to the court, we all know what the facts are. There are no material facts that are disputed, and you, judge, can make a decision as a matter of law and rule in favor of either the plaintiff or the defendant. And essentially, the judge basically denied both of those motions for summary judgment, indicating that there were material facts that needed to be heard and decided by a jury. But in reaching that decision and ultimately publishing a written opinion, Judge Rakoff did dive into some of these important issues and the interplay with the First Amendment and how they sort of play out in the context of a claim based on an NFT.
It's interesting to read the summary judgment opinion so, immediately before the jury decision, because Rakoff's decision, does make some legal holdings and does acknowledge that there absolutely could have been infringement, but also that this is clearly an artistic project, no matter how much Hermes argued that it wasn't. And that so the First Amendment analysis, which we call the Rogers test, which we'll talk about, has to apply here. So you're kind of seeing, I read it, you're seeing him sort of go in this direction of, it's art, we have to be really careful. I'm really feeling hesitant about, deciding an infringement case to shut this kind of expression down. And then the jury, of course, we don't have the benefit of a long written decision from them. The jury's, said, no, it's clearly trademark
Yes.
trademark infringement across the board. Not a lot of damages, which we'll also talk about. But so it's just interesting. It almost seems like they were going in slightly
Opposite
different
directions.
ways.
Yeah. So let's start with this question of is this art, and why is that important
To the analysis.
to the analysis? Because there are two different tests that can be used depending on whether this is considered to be art or whether it's just a commercial use. And maybe let's start there, Emily.
Yeah, what's trademark infringement? And then why does it matter what type of mark it is? Or service?
Sure. So at a basic level, trademark infringement happens where consumers are confused about the source of goods. They think that Tiffany blue box, going back to that analogy, came from Tiffany's, but in fact it,
Came somewhere else.
it came from Mr. Friendly's jewelry shop,
Just let me stop you for 1 second, because if you're a plaintiff trying to prove trademark infringement and you have to prove that consumers were confused, how do you do that?
You usually do it through surveys.
Okay.
So there are, in fact, experts out there in the world. There's a couple of different ways. I mean, if the issue sort of goes anywhere, if it gets sort of beyond the initial stage, you usually use surveys of consumers. Those are supposed to really be actual people who are in the market for the good that is at issue. So here it would have been people who are presumably out potentially buying an Hermes bag. And
It's a very small market, relatively
pretty small
speaking.
You can survey all of them, actually.
And I think that's actually, there's some interesting discussion around that in this case that we can talk about later. There's also sort of a presumption there that the more expensive a good is, the more careful consumers are in purchasing that, and the less likely they are to be confused by, a somewhat similar or close trademark or
How
potential.
discerning are the computers?
Yeah. So, you're going to look for a different level of consumer confusion when you're talking about a pack of gum versus a $10,000 handbag.
Right. But so this sounds like it's a very discovery-heavy, fact-intensive inquiry, not suitable to a motion to dismiss, typically.
Correct. There are times where either because of First Amendment concerns or because it's just so clear that there was no consumer confusion or the plaintiff didn't allege really any consumer confusion, that a case here could get thrown out at the motion to dismiss stage.
Right. Or it's not actually a trademark.
Or it's not actually a trademark, or the trademark doesn't actually cover the use that somebody is complaining about.
All right, so we get to this sort of trademark infringement level where there's a similar looking mark, there's consumer confusion about the source identification, but then we branch into these two different analyses. And clearly Hermes anticipates this in its complaint. It's a very long and detailed complaint because it goes to great lengths both to explain why this is confusing, listing public examples of actual confusion, magazine articles, public statements by third parties, Instagram that says, look, Hermes is getting into NFTs. Isn't this great? I think, well-known magazines that Hermes had to correct.
I believe, was it Vogue or
Vogue,
Elle?
Yeah.
There was some confusion in trade publication.
So not minor,
Yeah.
that Hermes points to say, actually there was confusion. And then they also go to great lengths to plead that Rothschild is, a marketer and business person only concerned with profits, basically that he's selling widgets and nothing more to make money, and is a masterful marketer, but not an artist.
Correct. I think it was in the amended complaint, and in various, maybe in the opposition to the motion to dismiss, they make a huge deal out of saying, this is just a guy who's into marketing.
And cares about making money.
Right. Which the judge rightly pointed out is irrelevant.
Yeah,
because artists are entitled to make money.
Right.
It's not...
and a documentary film has huge First Amendment protections, and certainly, Michael Moore is happy to make money.
So why do they anticipate that? Why do they go to great lengths to say, this guy's not an artist, this stuff isn't art, and we know why, that there's substantial consumer confusion here already.
So they go because they want this case to be decided solely on the basis of consumer confusion. They don't want the court weighing and bringing in First Amendment concerns into any kind of analysis of their claims against Maison Rothschild.
And why does that change things? It sounds like there's a two-tier analysis here, and you want to be on, if you're a brand, you want to be on the non-First Amendment track.
Yeah, because it's fewer hoops to hop through. It's a lower standard. We can talk, I think, about what standard actually got applied here.
Yeah.
But basically, there's the court here sort of sees this as a fork in the road where you either go to Gruner and Jahr, which is sort of straight up were consumers confused,
Right.
Or do you have to first look at Rogers v. Grimaldi and determine whether you even get to the point of looking at consumer confusion?
Because if it's artistic expression, trademark law doesn't apply unless there's some much more extreme behavior going on.
Correct.
And we don't need that extreme behavior if it's not artistic expression.
Correct.
Because we've decided as a policy matter and now in the law that for commercial activity, the First Amendment doesn't come into play. That's not speech implicated by the First Amendment.
Purely commercial speech that does no more than propose a transaction is purely commercial speech, doesn't get First Amendment protection.
Yeah. I think if our listeners feel like that is a fuzzy line, that I feel that as well, right? I mean, advertising, marketing, the overlap between commercial activity and what is artistic expression is not at all clear.
No, it's difficult. But I think, going back to what you said earlier before, Emily, the fact that these Meta Birkins seem to be taking a slightly ironic, making fun of perhaps approach in the materials, the sort of gauche materials that are being simulated digitally, seems to suggest a kind of parody-like approach.
Yeah, absolutely, or a little bit of a poke to an establishment,
Exactly, which is
thumb in the eye or whatever you want to call it.
One of the things that underlies the concept of fair use and copyright.
Right. Right, it is the way we protect the First Amendment.
Right. Yeah, I mean, there's certainly parody going on. Or at least I see parody. I think maybe the jury didn't. I see parody. I certainly see a lot of commentary about, we haven't really talked about it, but one of the points I think that Mason Rothschild makes is he is, at least in his telling, commenting on people's willingness to plunk down a lot of money for this thing that doesn't have...
Something silly.
Yeah, it doesn't really... it has that value because people think it has that value, and it has that demand because people demand it. There's not... it doesn't clear the snow out of your driveway or...
Right. And I guess we should say, because this raises so many of the issues we talk about in copyright law, it's not the same that, things like parody or different forms of artistic or social commentary or cultural commentary provided a defense to trademark infringement. But there's a way in which trademark law developed, as we talked about, where the analysis gets stricter if we're talking about the same kinds of things that would get you into a fair use analysis in the copyright realm.
Exactly. The courts have sort of given room to creators to use brands in a couple of different ways and said, in these particular cases, we're going to say that trademark law doesn't apply, or we will not find a later user to be liable.
Right. So the court, on summary judgment, says this is artistic expression, at least a little bit, and even if it's just a little bit artistic expression, we get into the Rogers test, which is this much stricter First Amendment protected test, even though Hermes has argued since the beginning that there's nothing artsy about this, the judge doesn't buy that.
Right.
So he decides summary judgment on the Rogers test. But the Rogers test, which maybe, Emily, you should describe, and we can talk about actually the Rogers case itself and how it sort of developed this test, it still allows for liability.
Correct. So just to go back to, I actually kind of love the Rogers, because it's just such it's a fun case. Ginger Rogers. So I think it was in the late 80s, I think Rogers was decided in 1989, I want to say. So the case is brought by Ginger Rogers against a company that produced and released a film called Fred and Ginger. And the film, I believe, is directed by Fellini.
Yeah.
Yes.
And it involves two fictional performers who go by the stage names of Ginger and Fred. The film as a whole sort of contrasts the banality of the world in which this sort of post-World War II world with the sort of elegance of Fred Astaire and Ginger Rogers, and it's sort of meant to be a comment on that. Anyway, Ginger Rogers sued the producers of the film, saying they were trading on her name and suggesting that she had somehow endorsed the film. And the court went through, created this analysis, said there's a couple of things we're going to look at to see, in the case of a name that involves a trademark, if trademark infringement exists. And one is whether the name has any artistic relevance to the newly created work. So in the Rogers case, the movie. And the other thing we're going to look at is to see whether it's explicitly misleading.
Or as the court in the Meta Birkin case described it, intentionally misleading.
Intentionally misleading.
Which is a little easier to understand. Okay, so if there's any relationship between the use of the mark and the artistic expression, First Amendment protections come into play.
Correct.
And then we would look at, even so, was the alleged infringer doing it to intentionally mislead consumers?
Correct.
Okay, so it's a harder test.
Right, and that in the same way that we see it, the fair use defense developing, if you want to poke fun at a Birkin bag, you have to use in some reference to the Birkin bag. Otherwise, you can't express that thought.
Right. I mean, you have to have an intent. And I think it's sort of an interesting question as to whose intent and how you're sort of viewing it.
Right, for the
From
Roth
which,
case.
from
that's-
whose standpoint.
Right, and it sort of raises an interesting question about Mr. Rothschild and the way he presents himself, and whether or not, if in this particular case he had been a little bit more explicit about his being an artist.
Why didn't he just, if he just said, I'm an artist, here's my art collection, would that have mooted the whole case?
I don't think it would have mooted the whole case. I do think that, and certainly Hermes made a lot of hay out of it, he brings a certain baggage to it. He has a background. He does have a background in marketing.
Yeah.
And I think that it's entirely possible. And also I think his explanation for the project evolved a little bit over time. And he probably could have, with good legal counsel, or somebody, made it a little easier on himself to set up a record that this
was an
was
art
in
project.
fact
Yeah.
art. I personally think it's art.
Yeah, I agree.
Yeah.
Well, and that's also maybe why Hermes, again, didn't bring copyright claims, and they didn't focus on the image, right? They were
Correct.
focused on the name, and I think that's because they understood that in a fair use analysis, in the, very creator protective realm of copyright, the use of an image, altered image, commenting on an image, feels much more like art than the use of a name.
Yeah.
And so I think that was a smart decision, and that the case is harder with the use of the name, in all caps, rather than just looking at the picture, which feels like commentary or some kind of expression.
And it's not, even if you take a picture of an actual Birkin bag and you hold it up to a Meta Birkin, they're not similar. If you're talking about the copyright realm,
Right.
you look at these two things and go, oh no, they're different.
Substantial similarity,
Yeah.
maybe not even there.
Right, it's
So.
different. And also there are other complicating facts. We don't want to make it seem like the jury, we weren't at the trial. First of all, we don't know the basis of the jury decision. But there were plenty of facts on the record prior to trial about him doing this to try to get an Hermes partnership, that he had very commercial motives, that he was, kind of baiting Hermes by using their mark. So there are facts in the record that lean towards that his use of the name not always being for artistic purposes.
And this sort of goes back to the point I was making, which is that I think he could have made it, he could have made the case a little easier for him to win by sort of being a little more proactive before launching this.
Yeah, the
product.
practice pointer here is call yourself an artist and
Yes.
label your store an art, like an art exhibit or
Right.
an art boutique.
Yeah. Who knows what it would have done to the promotional value of these things, but it seems like it couldn't have hurt.
Yeah, and I think also being a little more, like I said, it seemed like his story about why he was doing this evolved over time, and I think being a little more, starting the project with more of a clear narrative about the commentary or the parody probably wouldn't have hurt.
I want to also just say that, part of Hermes's argument that the jury had to buy was that even though they don't produce any NFTs now, that they might want to, and they have the right to do that. And if they did that, then this would be confusing because there'd be his NFTs out there with the Hermes logo and using the Birkin name, and then there'd be their NFTs out there, but they don't have NFTs yet. So this is a very prospective consumer confusion argument, which, of course they can make NFTs. Other very high-end brands have gotten into the NFT market. But I just thought that was sort of interesting that they may not ever do that because it may not make sense for the kind of company Hermes is to mint NFTs and make that part of their business model.
Yeah, look, I'm a lawyer and not a marketing expert by any stretch of
None
the
of us are,
imagination.
yeah.
But it's really hard for me to see how this brand that is so focused on like physical luxury goods and goods made out of like the most exclusive materials is really gonna
And handmade.
is,
Sewing.
Right.
yeah. By a skilled artisans, somewhere in the mountains of Italy is going to
out of ostrich, skin.
shark skin or ostrich or whatever.
But I guess I would maybe push back a little bit on that, just because I think, to me, the cyber squatting claim seems a little bit more potent to me. Like, because
A little more
potent or
convincing.
Convincing. Because even though, I take the point about the type of company that Hermes is, but, we see sort of in the art world a lot of artists, trying to jump on that NFT bandwagon who you wouldn't necessarily think of as artists who would sort of tilt toward NFTs.
And high-end galleries.
And high-end galleries that follow that.
museums.
So if there was, some evidence that Hermes was contemplating, getting into that market, that just strikes me as more interesting than the trademark infringement and dilution. But should we talk about the jury verdict?
Yeah, I mean, we don't know a lot. We do have the court's instructions.
Well, let's just start with the actual result, and then we can maybe work backward to the instructions, because we know that the jury had to indicate, and we can publish the verdict form. There were really 3 questions on liability. Do you find the defendant liable for trademark infringement? Second, trademark dilution, which we haven't really discussed.
But very similar.
Similar. And then cyber squatting. And all 3 of them, the jury found that the defendant was liable. But the one that I think is kind of intriguing, given the judge's decision that we're talking about, the jury then had to make a determination whether or not, having looked at the claims for infringement, dilution, and cyber squatting, whether the First Amendment protects Rothschild from liability, and they found very specifically that it does not. So in some ways, implicitly, and maybe if we look at the jury charge, the jury was saying, we don't really consider this to be art.
Or I think what the instructions say is, Rakoff says, this is art, guys. There's at least a little bit of art here. So what you have to decide is, first, is there infringement? If you find there's infringement, then we go to step 2, which is, given that this is artsy, even if not full-on art, if it's a little artsy, did Rothschild try to intentionally mislead consumers? I think that's what the analysis is, and they must have found that he intentionally tried to mislead.
Yeah, I agree. I mean, I think that's the only real way that a jury reaches this.
Because Rakoff didn't really allow them to say it wasn't art, at least.
Correct. No, I mean, the jury instructions, I think, presumed that there was some artistic expression. I don't think that Rakoff gave them a whole lot of guidance about what they were supposed to be looking for, or sort of the degree of intentionality that was required. Yeah. It just said sort of, hey, if it's intentional or explicit, then no First Amendment protection. And I'm not sure that squares with either Rogers or the Twin Peaks case, which is another case that sort of came after Rogers, that sort of talks about balancing the protections for brands of the Lanham Act, of the trademark law, and First Amendment protections.
Tell us the gap. What?
Well, I mean, all of the case law sort of says if there has to be sort of a heightened standard where there's some First Amendment protections, but it doesn't really say what that heightened standard is. And certainly I don't read Rakoff's instructions or the court's instructions to the jury as giving any guidance as to what that heightened standard
Except
is.
that he uses the word intentional,
Correct.
which is a lot more concrete than explicit, which I guess he assumes they're synonyms, but
I'm not sure that they are, but I'm not entirely sure that they are.
yeah.
I mean, look, I mean, we're lawyers. This is a legal matter. I mean, intentional means you did something on purpose.
Yeah.
And that's really looking at the creator's motivation, whereas explicitly really goes more to how something is perceived by somebody, by a third party.
Yeah, or how it's expressed.
Yeah.
It seems like that instruction is the thing that could potentially, form the basis of an appeal by Rothschild. I guess as we're sitting here today, he's got a few more days
Yeah.
to file a notice of appeal, but he hasn't so far.
I believe he said in press statements or Twitter or somewhere that he plans to, but
Yeah.
and I don't know if you guys have any insight. I'd love to know. I mean, we can talk about the damages. The total damages here were $133,000, I think, which is
Yeah.
not a lot of money given,
Much more than Hermes paid to litigate this.
Oh,
by
yeah, and
zeros.
probably much more than Mason Rothschild paid
Yeah.
to litigate this,
Right.
but it'd be
Much less, yeah.
much less. Sorry, it's I mean, an appeal is a lot more money, and I don't know who's sort of funding the litigation from Mason Rothschild's. I mean, I presume there's investors of some
So
kind
it's
in the project.
actually, it's a,
And he's made some money, though. I mean, so presumably he could probably pay for it.
yeah, but
He's made some money, but I mean,
it's the damages, but it's also the judgment of the court that prohibits future activities. So Hermes, even though they're not getting a lot of money, they make out pretty well, even if they got no money, because he has to stop
correct.
selling these, marketing them. They can't be displayed. They got what they wanted, even if they're not getting paid back for his profits, which is probably not what they cared about.
Yeah, I
even
don't
in the
think probably $1 billion brand or whatever they are. I don't know how much they're worth, but it's a lot.
I keep coming back to why Hermes was so threatened by this. I mean, that's the really interesting question. They saw this as something
An
they had to do
existential threat.
for like brand protection hygiene, and
Yeah.
that, I mean, this is my guess, that maybe not this case or this example or right now these sort of spin-off NFTs were going to be a problem, but that they could be.
Yeah, I think that's right, and I think that looking at it from the perspective of 2023 versus 2021, early 2022, I mean, I think it's a little bit easier now sitting here in 2023 to be like, God, they were threatened by NFTs, really? But I think, if you think back to late 2021, early 2022, everything all the time was NFTs. It was
Yeah,
like, it
we know
came
that.
like from, I guess, I want to say August maybe of 2021. It just sort of
Right. I think the Beeple sale was in
Yeah.
May, so then things started to really
take off. And I feel like by August it was like everything, like NFT everything.
Yeah.
And we'd been living in a sort of pandemic world, and everybody was much more focused maybe on their phones than going out to dinner, and so it was easy for things to take off and sort of install themselves in people's imaginations. So I think Hermes was very threatened by this because it was unclear in late 2021, early 2022, where this was going, and there were people making insane amounts of money overnight.
Yeah, and only because they were referencing other
NFTs,
brands.
yeah.
I think, we're not a fashion law podcast, but this really does tie into how difficult it is for fashion brands in particular to protect their product, right? You can have very artistic or, distinct looking clothing that does not get the same type of protection as fine art, right? And this has been a struggle in the fashion industry for a long time, and there's this push-pull in the law about whether, functional objects, what kind of protections they can get. And so fashion brands have really had to rely on trademark and trade dress when they'd much rather rely on copyright. But the law hasn't really permitted that because we call it functional, no matter how pretty and non-functional, like the ruffles or the pattern or the sewing is. And so I think, I'm guessing that, one thing Hermes and many other brands felt like is, oh my God, this is one more area in which
We have to hold the line.
Right, we're going to be exploited, and we might not have the legal tools, or we need to establish the legal tools to protect, because we're already all the time dealing with counterfeit goods and having to fight about it.
Yep. And I think that these brands have, again, to the sort of idea of a push-pull, they have this fight of being exclusive, but also like installing themselves in sort of the consciousness, in everybody's consciousness, so that they're desired. And this maybe goes back to a little bit of what Mason Rothschild was getting at with the Meta Birkins project. You can have a jacket that is exquisitely made and made out of beautiful wool, and that has, or beautiful fabrics, and that has value because it's going to last a long time, the quality of craftsmanship. But a lot of it also is just like they want people to buy stuff, and like they want sort of to generate interest and demand.
Yeah.
And there's not necessarily a reason for that.
Yeah, and that's, I think, one reason why courts and legislatures have felt like fashion is different than art. That, no matter how pretty you make it, it's about branding, it's about selling multiples, it's about use in a way that fine art isn't, and, has more protections. So to finish, Emily, how general, there's been a lot of attention to this case. Like, people who don't know anything about art or fashion thought this case was interesting. It's the intersection of a lot of different worlds and concerns. How generalizable is the outcome of this case, going forward for NFTs and NFT creators or fashion houses?
Well, I think it's it's the first case to go this far, to go to, a decision in liability that involves NFTs. There have been a couple other cases filed in late 2021, 2022. I think almost all of them have settled or are still pending. There is that. Like, anybody who sues and it's a case involving NFTs are going to go, oh, we got to look at Hermes versus Rothschild. On the other hand, it's, this case has its own particular facts, and those are not necessarily generalizable. And if another artist does something where we've talked about maybe pays more attention to sort of the backstory and making sure that that his or her project is perceived as art, then, we may come with a different result. I think also it's going to depend if this case goes to the Second Circuit and it is appealed. That's going to be one thing. We're going to have a decision presumably then from the Court of Appeals.
Right, that will have some binding effect in the whole circuit.
Right.
Yeah.
Otherwise, yes, the Southern District of New York has an outsized influence probably in the world of media and art and fashion in the United States, but it's one judge and it's one jury, and we've talked a little bit about this. The jury's reasoning is a bit of a black box. Yeah. I think it's a somewhat limited
I guess one
application.
takeaway for me, which is not necessarily, it doesn't have any legal general applicability beyond this case, but just is that maybe, as we talk about in this podcast, the perspective of people in the NFT world, the perspective of, the art world is not how a random sample of people who live in Manhattan and end up on this jury understand this question of fairness or expression or what art is, that the jury just didn't get it. And maybe that's not because they missed something obvious they should have gotten, but just that normal people could make a fair assessment that these kind of NFT projects aren't that creative. Or they're not that important.
Yeah.
But interestingly, too, I think Judge Rakoff's decision may have some lasting, legs, because he did grapple with this just overall question as to whether or not this was art, and found that it was, and applied the Rogers test. And I think that's a decision that seems fairly solid. And so the fact that the jury in this particular case kind of went in a slightly different direction than the judge was seemingly going is just the function of juries.
Right. Right, his case will be cited, which was his intent.
And it's interesting that he decided that this should go to a jury. That he found that there was enough, that the First Amendment concerns weren't so pressing that it couldn't go to a jury.
That's right. Yeah.
Oh, that's interesting. Yeah. Well, I guess that goes to his feeling that there was ultimately, even at the very end of the First Amendment analysis, a decision on intent.
Correct.
And that's when he couldn't make.
Hard to, unless it's the evidence is so overwhelming.
Yeah.
Hard to decide that without a jury.
Yeah.
Right. But this goes back to what we were talking about, whether there's any difference between explicit and intentional.
Yeah.
Or explicitly and intentionally.
Yeah. Maybe setting up some splits in different courts.
All right.
Thank you, Emily.
Thanks, guys.
Thank you, Emily. It was great to see you.
Good to see you.
Yeah. And that's it for today's podcast. Please subscribe to us wherever you get your podcasts, and send us feedback at podcast@schalaw.com. And if you like what you hear, give us a 5-star rating. We are also featuring the original music of Chris Thompson. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
The information provided in this podcast is not intended to be a source of legal advice. You should not consider the information provided to be an invitation for an attorney-client relationship, should not rely on the information as legal advice for any purpose, and should always seek the legal advice of competent counsel in the relevant jurisdiction.